afternoon, everyone. My name is Nell Cordick. I am a senior advisor with Bogart Wealth and a certified financial advisor. Also, I have the designation of a certified financial planner. Today, we are doing our webinar on estate planning and charitable giving. I want to emphasize that as we talk about this particular topic, estate planning is very individualistic to your specific needs. So as we go through and I highlight some of the topics that I think are important, keep in mind that everyone's estate plan is very unique. I also want to mention that I do have our question and answer box open, and I will try to monitor that as we go through the webinar as well. For those of you who might be new to our firm, our mission is to help clients achieve financial peace of mind by preserving and maximizing intergenerational wealth. Little background on us, we have about $2.9 billion of assets under management, and we work with around 1,377 households. We are a registered investment advisor, which means we are an independent fiduciary advisor working in your best interest. We custody our assets at Charles Schwab for your protection, and we are a fee-only wealth management firm. We basically have a full operations and financial planning team in our Virginia and Texas offices. The next couple of slides will just highlight our employee group. We have our executive leadership team. We have our group of financial advisors located both in McLean, Virginia, and in Houston, Texas. We have a full operations financial planning team. Portfolio management team is represented here. Our client services team, our financial planning team, and then our support services, HR, business development, training, and marketing teams. We have 3 offices. Our headquarters are in McLean, Virginia. We also have an office in Gessner in Houston, as well as the Woodlands. We provide a number of educational webinars throughout the year, and we invite you to join future webinars as topics that you may be interested in. On our website, we do have some recorded webinars or recorded versions from our previous webinars as well. Today's topic is all around estate planning. I will say it is one of the topics that people tend to delay. People do not like to talk about the inevitable, about what will happen at some point in their lives, and therefore they put off actually constructing their estate plan. So today we're going to talk about what is the estate plan, who needs it, what are some basic planning concepts and considerations, and a little bit about the different documents. I do want to preface at the very beginning, I am not an attorney. You will need an estate planning attorney to actually write your documents and advise you on the content within the documents. However, we would want to educate you on some of the things that you want to be thinking about in advance of preparing your documents. So first off, what is an estate plan? It is simply a map that says, what do you want to happen to yourself as well as your assets in the event of incapacity or death? And it really just lays it out. I also want to emphasize that even though you might construct an estate plan today, you can always adjust it, make changes at some point in the future when either your circumstances change or your wishes change. And a good estate plan also will cover all of the what ifs that could happen, because we don't know what life is going to present to us at some point in the future. So a good estate plan will have the flexibility to be able to work within those constraints. So who does need an estate plan? Basically, without an estate plan, You cannot control what happens to your property if you die or become incapacitated. So basically, an estate plan makes your wishes clear. It will help avoid family disputes, and it will preserve assets and provide for loved ones if for your wishes. It is especially needed if you have controlled all of your financial matters and your spouse is not as comfortable handling financial matters, if you have minor children, if your net worth exceeds the federal transfer tax exclusion, which is 13,999,000 in 2025, if you own property in more than one state, and if financial privacy is a concern, and if you own a business. So, a couple of things that I want you to think about that are frequently asked questions around estate planning that are common, that we hear quite often. Number one, what is probate? We'll talk about this. All of these questions we'll try to address as we go through the webinar. What is probate and how could it affect me? I would assume that everything goes to my spouse. Is there an option for that not to happen? Do I have the right beneficiaries on all of my accounts? If I am incapacitated, who handles everything? What happens to my children if something happens to me? Where do my assets go when I have passed away? What is the difference between having a will and a trust? Also, what's the difference between having a trustee and a power of attorney? Why would I need both? How can I help to preserve more money for my heirs? And then who knows where to find my records? Where should they be kept? And to make it easily accessible. All of those are very common questions, and there will be additional more. However, these are some things that you want to make sure that you have thought through as you're creating your own estate plan. So basically, the first thing here is we want to talk about just some overall basic estate planning concepts. So number one is planning for incapacity. Obviously, that happens before you die. So therefore, you want your documents to reflect your wishes if you are not able to speak or act for yourself. What about healthcare? What happens, again, do you want your wishes to be known before you pass away regarding how you wish for your health to be taken care of? Property management, if you own assets and real estate, how do you want those to be managed? What is happening regarding taxes? Decisions can be made that can help to adjust taxes. Can't really avoid taxes, but we can certainly try to make them the least as far as they may be, to try to minimize them as much as possible. Lifetime giving. If you have a desire to give to to anyone that is important to you, what would be the rules around giving to them during your lifetime? Charitable giving. If you have the desire to give to charities or philanthropies during your lifetime or upon your death, how does that play into your estate plan? How does life insurance make a difference in your plan? And then you find planning for death. So you want to make sure that everything that's during your lifetime you've covered, but also at whatever point that you do pass away, things are really airtight in terms of the way that you want your assets to pass so that they will follow your wishes. And then documents, wills, probate, trust, all of the different documents that may enter into your estate plan. So first we want to talk about incapacity. Incapacity means that you are not able to function on your own, or make decisions independently. And basically, the statistics are that 25% of 20-year-olds today will have some sort of a disability before they reach age 67. So it's very important to plan for what has to happen if you're incapacitated. So the key things there that you are planning for is, number one, who takes care of you? Who takes care of your assets? Who provides for your needs, and or who makes decisions to provide for your needs? And then if you have minor children, who makes the decisions to provide for your minor children as well? And in what capacity, what are your wishes? So all of those things are very important things to think about for incapacity purposes. So what are the documents that would cover incapacity? So we'll first talk about a living will, then a durable power of attorney for healthcare, and then basic do not resuscitate orders. So the living will is basically a document that puts your healthcare wishes in writing. It specifically says, what happens if such and such happens to you? It gives a lot of different choices as far as what your wishes are. It could be a temporary incapacity. You are in a car accident. You have to have surgery. Someone has to make decisions for you. Or it could be something permanent, meaning Alzheimer's disease or something like that towards your end of life. But basically, you put it in writing for different reasons or different purposes of incapacity. This particular document will specify, what do you want to have happen? Your durable power of attorney for healthcare then designates, who do you want to make those decisions? It will designate an agent to make those healthcare decisions for you. And in some states, these two documents are combined into one, and in some states, they are kept separate. So that's one thing about estate law, is that every state has different estate laws. So when you move from one state to another, it's a good idea to have an attorney review your documents to see if anything needs to be adjusted to comply with that particular state law. And this is one example where different states may combine these two and may have one. Would also like to point out that typically you will appoint a primary power of attorney for healthcare. You also appoint a secondary, so if a contingent. So if the first person is unable or unwilling to work in that capacity, you automatically have the second person in line to take over those decisions. And then a DNR order, you're probably very familiar with that if you've ever been hospitalized for surgery. They typically want to have a do not resuscitate on order on file, either with the hospital or with your primary care physician, in the event that something does happen unexpectedly. It's your wishes are known. I would also advise that once you've created these documents, I would share them with your primary care physician so they are very much aware of what your wishes are. They can then help facilitate with your agent in terms of what the proper actions should be. Secondly, if you have incapacity regarding your actual assets. So again, there are 3 ways of handling that particular situation. And again, this is while you are still living. If you have accounts that are titled joint ownership with another person, the joint owner has 100% access to that property that you do. So a lot of times you will see this in liquid bank accounts, so that there's always liquidity that a joint owner has access to no matter what. Then a durable power of attorney. And the reason that it's got the word durable in there is because it's really giving that person the authority to act as you would. They are given the same authority to do just about everything that you could do yourself, but they would be doing for you. And this is, again, an agreement that designates an agent to make the decisions on your behalf regarding your actual real assets. Now, again, we do recommend that you create an agent and you create a contingent in the event that the first person is unable or unwilling to serve. You've got a backup. Typically, a durable power of attorney would be used for an IRA. An IRA always has to be kept in your own personal name. It can never be joint, and it can never be in your trust. You can make the beneficiary be your trust, but it cannot be retitled as your trust. So you would always need a power of attorney that can actually handle your IRA assets if necessary. And then the third type of ownership is regarding a living trust. Also think of that as a revocable trust. So typically, when you are living and healthy and totally in control, you are your own trustee. However, you put into your trust, you name a successor trust and probably another successor trustee. In the event that you're unwilling or unable to serve, the successor trustee can take over for you in the event of incapacity. And the successor trustee actually can govern any accounts that are titled in the name of the trust. So a power of attorney will facilitate accounts or assets that are titled in your personal name. A successor trustee will handle assets or accounts that are titled in the name of your revocable trust. It's a very important distinction. And you really, if you have a trust, you need both of these designated. You don't have to have the same person as both, but it is usually a good idea so that your total accounts are being looked at from a totalitarian perspective. You do not need to have your healthcare agent be the same as your successor trustee or your power of attorney, but they could be, but they don't have to be. So what happens if you haven't done any estate planning and you don't have any of the proper documents? Number one, assets that have a joint owner or a designated named beneficiary will automatically pass to the joint owner or to the designated beneficiary. So those assets are protected from probate accordingly. All other property would pass according to the state intestacy laws. They also would require you to go through probate. So what probate is accounts or assets that are in your individual name, don't have a joint owner, do not have a beneficiary, would be required for the court to oversee the distribution of those assets. And if you don't even have a will, so if you have a will, those assets would pass according to your will. If you do not even have a will, then they pass according to what the state says of how they should be distributed. And the danger there is it could be very different than what your own wishes are. So for instance, these laws vary from state to state. Typically, they will have a pattern that will usually give something to the spouse and then something to the children. Every state is different, but typically it might give 50% to the spouse and then divide the other 50% between all of the children. But that may not be your wishes. And so it's very important that you have documents specifying what your wishes are. So then we want to talk a little bit about kind of keeping in mind what are the tax implications regarding your estate as well. So the good news is that, first of all, if you wanted to gift during your lifetime, you can give $19,000 to any person or as many people as you want a year, and you don't have to have it exposed to a federal gift tax. If you go above $19,000 to any one person, then you would have to file a gift tax return. Now, I do want to point out that if you are married filing jointly, you can actually give $38,000 to each individual person, because you can put the gift exclusion of both spouses together. However, 19,000 is the limit for one person to be able to give, but there are no gift tax returns that have to be filed, and there's no income tax on the recipient either. So basically, if you transfer your assets upon your death, there is a federal estate tax that is put on those assets above the exemption amount. Now, the exemption amount, as I mentioned, is $13.990 in 2025. It does go up to $15 million in 2026. Married filing jointly would be double that amount. And so it's only above that exemption amount where the taxes are imposed. And so you also get that reflected in the generation skipping tax. If you try to give everything directly to your grandchildren and you're skipping your children, they also will impose a generation skipping tax regarded in that way as well. There we go. So basically, the gift tax, if you are transferring it um, to someone, they don't have a tax imposed. It is that you may have to file a gift tax return. And as I said, it's 19,000 is the exclusion. This is where we talked about the full exclusion for the lifetime. And keep in mind that the new 15 million that they have established is the largest that we've ever seen in the history of the federal gift and estate tax. Again, estate tax, applies to transfers made at death. It is not applicable to a spouse. That basically, in as much as you want to transfer to the spouse, there's no limit for the most part, and also to charities. It's only when you are transferring it to anybody else besides the spouse. Same exclusions occur, and basically, that's really how that works. Generation skipping transfer tax may apply to transfers made to someone more than one generation below you. So it's just important to keep that in mind. Again, the same exemptions. And I do want to explain portability. So if you are leaving assets to your spouse and your exemption amount is not completely used up, the unused portion can be transferred to your surviving spouse. So portability allows the full 30 million starting next year to be transferred, even if your portion was less than the 15 million. So it's really a definite benefit to make sure all the proper documentation is carried out when the first spouse passes away. There are special forms that need to be filled out, and your CPA will assist, or an estate attorney will assist in making sure that those forms are properly taken care of. But when the first spouse passes away, that is very important to make sure that that is adhered to. Portability is not applied, however, when you do generation skipping. So that's also very important, as you can apply portability for the spouse, but you cannot when it is generation skipping. And this is just an idea of what the top rate is and what it has been in the past. So it's basically right now, it's 40% above anything that would be 13.99 million for an individual. That's the very top rate. It is a graduated rate that would occur as well. So there are some advantages to think about for lifetime giving while you are still alive. So one of the things is it does let you see the recipient actually enjoying their gift. Many times, we pass away very late in life, and our recipients don't really need that money any longer. They've amassed their own assets. So this is a way to also gift to people while they may need it at a greater degree, and you can actually watch them enjoying it. So again, you can gift 19,000 individually or 38,000 as a married filing jointly with no indication of having to do a gift tax return. When you gift those assets, you can give cash, you can give highly appreciated property from your taxable estate. So either stocks that have very, very low cost basis, you can gift, you can give property. I do want to point out though, if you're actually giving real property, the tax basis goes with the gift. So when you pass away, there's no step up in basis for the gifts that you've already given. So that's also important to keep in mind as well. If you transfer it upon your death, you do get a step up in basis for the cost basis from what yours was to what the value is at date of death. So it is important to keep that in mind in terms of understanding that when you gift, you're gifting the tax basis as well. So it's important to understand what are those, who you're gifting to, what tax situation are they in at that particular time. So you take into account all of those considerations. Again, the lifetime giving, you're excluded from 19,000 or 38,000 if you and your spouse make the gift together. Now, there's some additional things that you can do as well. So if you are contributing to a 529 for college savings, you can actually give 5 years worth of the contribution up front. So basically 5 times 19 would be 95,000 individually or 190,000 with your spouse. So if you're contributing directly to a 529 plan for a grandchild, you can actually gift 5 years in advance for that particular contribution. If you are giving directly to a school for an individual's tuition, that does not count as part of the gift. There's not a limit on the amount that you can pay directly to a school. In addition, also the amount that you pay directly to a medical care provider does not count towards the gift as well. So if you're paying it directly to a medical care provider for an individual's medical care, then you don't have to count that into your gift tax exclusion either. So on that theme, talk a little bit about charitable giving. So several different things that you can think of for charitable giving. So number one are called qualified charitable distributions or donations. What this is basically a direct transfer from your IRA to a charity while you are still living. Your limit is $108,000 for 2025. It can satisfy your R&D and not count as a taxable distribution, and it doesn't take effect until at least you are 70 and a half. So if you are taking money from your IRA and you're at least 70 and a half, definitely take some time to explore if this is an option that can help you save taxes. And we can run lots of different scenarios for you to look at it both ways to see, does it make a difference? And if so, is it worth doing it? But definitely once you're 70 and a half and you're taking money from your IRA, definitely look at this as an option. And then once you have to start your required minimum distributions at either 73 if you were born before 1960 or age 75 if you're born 1960 or later, to look at it in that perspective as well. It removes above the line income, so it's very significant towards affecting your adjusted gross income, which affects your Medicare armor bracket, as well as some of the other tax provisions that were recently added into the tax bill. There's also what is called a charitable remainder trust. This becomes an irrevocable trust. So basically, you would take a tax deduction at the time that you move funds into the trust. The income from this trust is paid to you or your heirs for a specified period of time. The income is taxable, just as an FYI. And at the end of whatever period that you specify in the trust, and sometimes it's death, to be honest, it might last your lifetime, and then upon your death, the charity receives the actual asset value as well. Another common is what's called a charitable lead trust, also an irrevocable trust. And what this does is exactly the opposite. You're putting money into this particular trust. The income is being paid to the charity for, again, that pre-specified period. Most of the time it is death. And at the end of that period, the remaining assets are then transferred to your heirs. So in addition, there's some additional charitable components to think about. First, a private foundation. Assets are donated by an individual or family. They are invested. At least 5% of the assets must be given to charities each year. This tends to be fairly expensive to set up because you do have to do quite a bit of legal work to set that up properly. And sometimes the tax advantages are not as favorable as other type of donations. So it's something to consider, but it may not be the most favorable option. Donor advised funds are basically donations of cash or other assets. You take a tax deduction in the year the donation is made, and then you or your successor can determine the amount and the timing of the gifts directly to charity. So this is very common. If you, for some reason, have a windfall of income, or you have a large amount of distributions, or a large amount of capital gains, or various other things, and you want a higher amount of deductions, and you're under 70 and a half, so you can't use the QCD option, this can be another option to affect your taxable income in any given year. And again, with our clients, we want to sit down and look at it lots of different ways, but determine when and if this is a viable option. And then finally, basically your non-cash donations, which are appreciated stock, real estate, tangible assets, intangible assets, etc., provide a tax deduction in the year that the donation is made, and it actually fully goes to the charity in the year you make the donation. So then upon your death, the other way that you can give a gift to charity is through a bequest that is actually written into your will or your trust. Anything that is a bequest to a charity that is in your documents is not considered part of your estate. Therefore, it doesn't fall into going over the estate exemption amount. So again, you can make that specific bequest accordingly. You can also make a particular charity the beneficiary of an asset account. I would say you want to be also very mindful of both of these, that if the charity is not in the US, definitely we need to talk with the custodian, which in our case, it would be Charles Schwab, to make sure that that charity could be named. There are sometimes when a foreign charity, it won't be acceptable. And so that is one thing, just as a consideration. If you're looking at a charity that is not a U.S. charity, let's do some behind the scenes review to make sure that it is acceptable, or else you can look at figuring out a way to give to that charity in a different manner. So estate documents, in terms of estate documents, let me, before I go there, somebody did have a question regarding the difference between the pluses and minuses of a durable power of attorney versus a trustee. So as I go through this portion, I think I'll explain that as I'm talking through these different documents. So the first really the will, a healthcare directive, medical power of attorney, and a durable power of attorney are absolutes. Everyone that is an adult, meaning age 18 or above, needs to have those three documents. Even think about your kids that are going to college for the first time. You need to have these things in place. They may not have a lot of assets, so the will just simply states who they want their assets to go to if necessary. But it's critically important for the healthcare directive and the durable power of attorney. If those two documents are not in place, you have no authority to assist your child who something may happen and they cannot speak or act for themselves. And therefore, again, the courts or the state will make a decision on who actually directs their healthcare and makes decisions for them. So virtually anybody that is 18 or above needs to have at least these three documents. Now, then depending on your own personal situation, do you need a trust? And we're going to talk about specific types of trust in a little bit as well. So let's talk a little bit about what, we've talked about what they are. So first of all, a will dictates what do you want your assets, who do they go to upon your death? Basically, the will determines who they go to immediately. You really don't specify control further than that. A trust, on the other hand, gives you control beyond just the date of death. You can specify with your trust other parameters. Well, I don't want my children, they can have 1/3 at age 25, 1/3 at age 30, 1/3 at age 35. Or they have to have gainful income from some other source before they can have an inheritance. Or lots of different parameters. You can put lots of restrictions or specific things that your wishes can be very clearly made in a trust, whereas a will simply says they receive it upon their death. So the other part of it is if you have assets that are only governed in your individual name, so they would either be governed by will or they have beneficiary designations, your power of attorney will actually govern those particular decisions. If you have a trust, your successor trustee governs those decisions. And the major difference between those is really indemnification law. For a power of attorney, the financial institution that is accepting the power of attorney are the ones who are taking the risk if it is fraudulent. they're the ones that actually, are held liable if a power of attorney has been presented and the financial institution has not done their due diligence and it is a fraudulent document. On the other hand, if a trust document is presented and a trustee says that they are the legally responsible as the trustee, and then the financial institution is not liable, the actual trustee is liable. So it really becomes differences. And so therefore, putting a power of attorney before a financial institution may require a little bit of extra scrutiny. It may take a little bit longer because it may have some extra scrutiny. Typically, a trust is going to require the successor trustee to sign a trust certification, and it's a pretty smooth process. In either case, or I would say most of the time, in either situation, whether someone is invoking a power of attorney or whether they're invoking a successor trustee, if it is for reasons for incapacity, they will require two doctors to give a medical opinion that the person cannot handle affairs on their own. So typically that's going to be required. If it is, and that's regardless, but it's still a little bit more scrutiny from a financial institution for powers of attorney versus successor trustees. But typically they can do the same thing. So keep that in mind. Now, there is a high fiduciary standard associated with both of them. Both the power of attorney and the successor trustee must follow what is in the best interest of the person that has been incapacitated. They must keep they are the primary beneficiary regardless. And so they must hold that as a high fiduciary standard. I would also say the power of attorney dies with a person, whereas a successor trustee continues on even after the person has passed away. So sometimes it also makes it a little bit less, streamless as you are transitioning from incapacity to after death as well. But important to note, again, if you have a will, it's a good idea to also add beneficiary designations to all of your accounts that match what your will says so that one document does not contradict another. But if you have beneficiary designations attached, you avoid probate. So that's also very important. If you are, if everything is titled in the name of your trust, then you have choices. So if it's a non-qualified account, naming it in the trust is all you have to do. If it is an IRA account, you can either choose to name your trust as the beneficiary or a specific individual as the beneficiary. And again, lots of questions around this. Your trust has to be written in such a way that it provides the correct language for the trust to be the beneficiary of an IRA, but it can be done. Again, everybody's situation is unique, and it involves coordination and discussion with your key advisors to determine what is the best decision for you personally in that regard. Life insurance policies, we're also going to go into that in just a few minutes as well, into a little bit more detail. But life insurance policies are also, can be in your personal name. They get owned by you and therefore they're part of your estate, or they can be owned by a life insurance trust, and then they are not part of your estate. So we'll talk about that a little bit more further. So again, just to reiterate, the will is, you have to have a will. It directs how your property is distributed. If you also have a trust, many times your will says if there's anything that we haven't titled in the name of the trust, it will automatically get distributed to the trust. It does name an executor and a guardian for minor children. And basically it's written, signed by you, and witnessed. If property does not have a beneficiary, it must go through probate court. Basically, the executor collects all the assets. They pay any debts. They file the tax returns, and then they distribute the property to the heirs once the court has approved that distribution. In terms of the pros, probate, it can be fairly modest, but it can also be expensive. It does require court supervision in distribution, and there is some protection against creditors to some degree. On the cons, it can be more time consuming, especially if it's a complex estate. It can take a little bit longer to get all of the titling redone. There can be probate fees. And if you have property in more than one state, you have to do what is called ancillary probate, which means that you have to go through the probate process in every state that there's property. So again, a big argument for doing a trust if in fact you have property in more than one state. And then it is anything that goes through probate is part of public record, and you may not want that to happen. So how do you avoid probate? Basically, you own property that is joint. You complete beneficiary designations for all of your property, or you can use trust. And you can make lifetime gifts accordingly. Now, today's age, we live in a digital age, and it's only become more so as we go forward. So we are also recommending that you start to think about your digital assets. You want to keep a log for what your login credentials are for all of your key digital assets. You want to specify who has access to your cloud, who can get your photos and your videos, who has access for your domain names, your intellectual property, your cryptocurrency keys. So there's a lot of digital components that you want to be aware of. You want to, take an inventory, list your intention for each of those, and then make sure you've got a safe storage space for your documents. So then we go into trust. So trusts are a legal entity. A trust is basically, it can help protect about how you can handle incapacity. It can avoid probate, possibly minimize some of your taxes or fees, allow professional management of your assets, provide safeguards for minor children, elderly parents, and other beneficiaries, possibly help protect some of your assets from creditors, and it gives you control over how those assets are distributed at any point in the future. So there are legal parties to the trust. The grantor is the person who establishes the trust and funds the trust. Typically, you are the grantor. The trustee is the person who actually makes decisions. Typically, and the beneficiary is the person who actually has the rights of benefit to the property. Typically, when a trust is set up, you are all three, but if you at any point in time cease to be the trustee, the successor trustee takes over, and you're still the beneficiary, but when you pass away, there's a different successor trustee and your beneficiaries also. So revocable trust, living trust, very similar. A revocable trust means you're creating it in your lifetime. You have the ability to change it, alter it, revoke it, do whatever you want to do while you're still living. An irrevocable trust means that usually upon your incapacity, it becomes irrevocable, and upon your death, it becomes irrevocable. So it cannot be changed at that point. There are lots of differences between revocable and irrevocable. Changes can be done with revocable, different ownership, a lot of what we have, kind of established. I would really point out that an irrevocable means that you are giving up ownership. That means you are also giving up control. Someone else is controlling it. If you create an irrevocable trust, you no longer have the ability to control it. And they somewhat can be a little bit more legally complex, but they can also have some additional advantages. Lots of different types of trusts that are out there. We talked a little bit about the charitable trust. Special needs trusts are created when you have a child or someone in your life that you want to have provisions for. If they are getting public assistance, you don't want them to inherit a large amount of money because that may take away their public assistance. So creating a special needs trust keeps it from being owned by them, but it's there for their benefit. Irrevocable life insurance trusts are trusts where a trust owns the life insurance policy. Generation skipping trust leaves it to a future generation. Marital trust and bypass trust were very common when the estate limits were much lower. Now that they are as large as they are, there's not as much use for these. However, these are still used a lot when there are situations regarding blended families. It is critical to talk with your advisor and your estate attorney as you are setting up your trust to determine the provisions in your trust, as well as what types of trust that you need to have and how to get them funded. So with life insurance, basically ownership is the key. So if you're setting up a life insurance trust, you gift the premium for the life insurance to the trust. The trust pays the insurance company for the life insurance on you. And then when you pass away, the benefit comes back to the trust and ultimately to the beneficiaries, but that full amount stays completely out of your estate. But you're no longer the owner, the trust is the owner. That is the key. And kind of have walked through those as well. So why would you actually create that? If you think you're going to have a taxable estate, this is a way to provide additional liquidity to the beneficiaries because of having a taxable estate. So that's something that, is used in those regards. So the things that you need to think about in terms of your to-do list before you see an attorney is think about who are your beneficiaries, what do they get, when do they get it, do you want to leave anything to children, what happens if there are minor children involved, what happens if you're incapacitated, and who are the people that are going to control this. It's the most important decision. Who are you going to name as your executor? Who are you naming as your power of attorney? Who are you naming as your medical care directive agent? Who are you naming as your successor trustees? These people have a lot of power. They can be individuals. They can be a corporate partner or corporate trustee in order to handle things for you. But it's very important in who you're picking for those particular responsibilities. And then, it's always a good idea to also provide a net worth statement to your estate attorney, because based upon what your current ownership is, they can also do key things to advise certain things for you as well. Again, special considerations. Do you have special needs beneficiaries? Do you have a blended family? I could do a whole separate webinar just on this because that really does create a lot of other things to think about. And if there's anyone that you specifically want to disinherit, again, make sure your attorney knows that because they can put specific language into the document that protects you as well. Providing for pets is becoming very common. Family business is critical to plan that accordingly. And then if you have a spouse or other beneficiary who is a non-citizen, is very important. So basically, I will just end with a conclusion. Just do it. It may not be perfect. You may have to make additional adjustments later on, but do the documents. Start it, get at least the basics in place. And again, you can always change something. If there's one little sticking point, get the documents done and come back and do an amendment to change that one sticking point at some point in the future. We, as always, welcome the opportunity to do one-on-one sessions with you, and would certainly welcome that to adjust that with you and meet with you one-on-one to discuss some of these particular issues with you and guide you on things that you might want to think about before you've actually scheduled your meeting with the estate attorney. We do have clients that are literally all over the United States. And I just want to check one more time to see if any additional questions. No, I think we're good. So that have come through, excuse me, accordingly. I do thank you. Excuse me. Thank you for your time today. And I hope you have found this to be interesting and thought-provoking. If there are any additional questions, I invite you to reach out to me directly or directly talk with your advisors. Thank you very much.